Unfortunately, I'm going to be very, very strict with the time allocation. So, Mr. Leroux, please. Thank you.
Gracias por esta invitación.
Thank you very much for this invitation, Co-Chair Valencia, Madam Valenciana.
Begin by thanking this committee for this invitation. This is a very important opportunity to raise again what I think it's a crucial issue for the present, but also for the future. And I'll be very brief. Privacy and freedom of expression are two very distinct rights, but that have to be understood linked, which is what I tried to do in my report. You cannot enjoy freedom of expression fully if you don't have the guarantee of privacy. The lack of privacy is actually a chilling effect, some people will call it, or an intimidating effect on the possibility of exercising the writing of ideas, the transmission of ideas. But it's also, and very importantly as well, a limiting effect on journalism and the protection of sources, the protection of information and the free press, which are all fundamental to a democratic society. All rights are equal, but freedom of expression is a right that facilitates other rights, and it specifically facilitates citizenship and citizen participation in today's world through the internet. And we have seen the power, this was mentioned in the last panel, when the population of Tunisia and the population of Egypt raised their voices. It is not a magic wand, still country with uncertain future, but it was very clear that voices were heard and dictatorships of more than 30 years were toppled. So I think we have to understand that this is essential. Now, what is the problem raising with surveillance? Well, number one is that surveillance can actually be legitimate when it is within the boundaries of the law and within the boundaries of a democratic society. Yes, the state has an obligation to protect human rights, but also to protect the security of the individuals. And I do not agree with the debate trying to link or to establish a conflict between the two of them. Both of them are possible simultaneously in a truly democratic society. And as a matter of fact, the protection of fundamental rights, I think, is essential to strengthening security because it strengthens democracy. So if surveillance was necessary for a criminal investigation, there are procedures to carry that out. Of course, the argument today is that with electronic communication and the digital sort of leap in the world, it is very difficult to get a court order in every single case. I understand that there is a problem of procedure, but a procedure should be established in which there is an authorizing body of the state that is not the implementing body of the surveillance. And secondly, there's a permanent parliamentary monitoring of these activities. Those elements are progressively being lost. Yes, there are some parliaments or Congress in many countries of the world that have the function to monitor these activities, but in reality the dimension is so monumental and so big that they don't have the capacity. There's even courts being created for this purpose, but these are courts that give sort of general authorizations for surveillance, which doesn't necessarily serve the purpose of protecting security. The bottom line, and this happened in Geneva during my mandate, is that we ended in a discussion between targeted surveillance and mass surveillance. I specifically believe that mass surveillance, and more importantly if it's done to a third country, is inherently a violation of privacy because there is no specific link or limitation to the exercise of power. Human rights and the balance of power of the state are always at odds in the sense that the state has an obligation to protect human rights, but also to never abuse its authority in the name of human rights or in the name of democracy. And yes, I insist, security is a serious problem. No one can deny it in the world of today. Belgium today, in this moment, is going through a very specific period, and the events of Charlie Hebdo in Paris have probably changed the attitude of public opinion in all Europe. But I also believe that it is important to respond in a very coherent way by strengthening democracy. When the terrible incidents in Oslo occurred by Mr. Breivik against the young children, The response of the Prime Minister of Norway at that moment was, we have to build a bigger democracy, a better democracy, a stronger democracy in civil participation. And I think this, in a way, is the way to strengthen. What are the principal dimensions of this? Is to understand, number one, is that security and freedom of expression and privacy can coexist. This is important. Secondly, that the question is a question of procedures. We have to implement legal, democratic procedures to have an authorized surveillance mechanism, whether it's domestically or whether it's abroad. Because many countries may have the temptation to say we respect the rights of our citizens, but it's really irrelevant for human rights to do it abroad. This is a very contradiction in its terms, because if we deny the universality of human rights, we're also denying the universality of Internet and the neutrality that Internet must maintain. And this is crucial to protect Internet itself. So I think that this is a very important element. And finally, we cannot have the acceptance of mass surveillance as something necessary. It always should be a form of targeted surveillance with a democratic authorization and with a monitoring democratic procedure by different other state institutions. Ideally, there should be an open debate in all societies with the participation of organizations from civil society, for which I congratulate this committee for doing this today. Human rights cannot take a second position to exports and profit, as was said in the past panel, but also human rights should be part of the agenda of security and not a separate second-tier element in the agenda of any nation. Thank you.
Thank you very much. También por su capacidad de explicarlo.
Thank you very much for having made that presentation so quickly. But, of course, we'll come back to you after the questions. Now, Madam Marianne Knoyer has the floor. Thank you very much, co-chair. I'm going to speak in German, if possible. That's my mother tongue, so wonderful.
Thank you very much for the invitation to speak here. Over the next few minutes, I am going to talk about the developments and problems with internet freedoms in autocratic regimes. So I'm going to be focusing very much on countries and regimes which restrict internet freedom or completely ban the internet. And I'd like to show what form that takes in a very concrete and empirical way, and what kind of measures are taken by these countries. The internet is a huge challenge for autocracies. They feel threatened by the internet, to put it quite simply, because the internet, and particularly social media, and the very quick and multimodal communication which this enables, threatens the stability of these regimes. So it is an enemy for these kinds of regimes. But on the other hand, authoritarian regimes make use of the internet because it also has a lot of potential which is attractive to them. They can use it for their own purposes. So that's something that we need to recognize as well. So what we are dealing with here is an ambivalent use by autocratic regimes, or an ambivalent approach to the internet on the part of autocratic regimes. You have some very tough autocracies which do not allow any freedom of the internet. And we see this in different regions of the world. This is focused very much in Asia and the Eurasian region. And we know that China and in North Korea this happens, but also Pakistan, Thailand, Myanmar and Sri Lanka. In Eurasia we have Belarus, Uzbekistan, Turkmenistan, but also Turkmenistan and Kazakhstan. And then you also have the United Arab Emirates, Saudi Arabia, Bahrain, Egypt, Syria, Iran, but also Turkey. And Turkey demonstrates that it's not just very hardline autocratic regimes, but also hybrid regimes that are taking repressive measures nowadays. What kind of developments have we seen? Well, first of all, autocracies are also very clever in the way that they technically block the internet or the way in which they control online communications. So the technical progress that is of use to the internet users can also be used to carry out controls. And we've heard that also from the speakers in the panel on control of technical data. But there's another development that has been noted. In addition to the technical surveillance and control, in recent years there is an increasing trend towards the extension of administrative or judicial-based measures. So in addition to the controls that these regimes exercise, for example, blocking or limiting control for the mass user, in addition to that, they take legal provisions or administrative provisions which focus on the content of online communications, and that can be used to pursue individuals and to persecute individuals. And that's why we see an increasing trend towards persecution of individuals in these regimes. So they've changed the way in which they approach this. Initially, they took a very defensive approach and quite an amateurish approach, but now they've developed a much more fine-tuned, much more proactive, and much more professional approach. And I'll just give you a couple of categories of the different measures that are taken, just to give you an idea of the scale of violations of human rights we're talking about here. First of all, you have random repressive measures that are taken. That's nothing new in the internet sphere. This is something that we're familiar with in relation to media and press freedom and freedom of expression in general. But you also have physical attacks or even assassinations of online journalists and bloggers. And we see the example of the Saudi Raif Badawi at the moment. And these kind of measures were often taken in a quite random way in the past. But there's a second level of control, which are really hard measures, which can be broken down into technical measures and these legal or administrative measures. I won't say much about the technical measures because you've already heard quite a lot about this, or you'll be familiar with those. Of course, there can be a complete block of certain networks, censorship can be used, filtering systems can be used, IP addresses can be blocked, or URLs, or there can be keywords included on blacklists, and searches can be done on that basis. But the legal measures, which I mentioned earlier, they focus on online activities and communication and the content of communication. And as I said, we have seen increasing use of this kind of legal measure in recent years. So content is defined, which is considered to be prohibited or illegal. For example, the protection of national security, the protection of minors against pornography, etc., protection against blasphemy, or the any offence to religious symbols, offences against the state order, or alleged defamation or dissemination of false information. So this area has become much more extensive in recent years, and this kind of bans on allowed content is being used increasingly. And this kind of measure means that within a national framework, a legal base is created for this kind of repression or the persecution of individuals, which can be the result of this. And I think that is problematic, because in a way it creates a moral legitimacy for this kind of measures. And the other way in which these kind of very tough repressive measures are taken are through administrative measures, and we have seen how this has become more frequent in recent years. For example, the state authorities can be used to exercise control over the internet. So this is given a legal veneer. Special units can be created to control for anti-state statements being made. You can have network commissioners being created, or you can have an obligation to register certain websites, because that is also something which makes surveillance and control possible. But thirdly, we also see that other types of measures which can be taken, which could be called soft measures. And in autocratic regimes, we see that there is an increasing use of the net to legitimize the regime itself. So autocracies themselves use the net, for example, through e-government programs or even e-participation programs, to present themselves in their country and to the people in a legitimate way and to garner more support. So through e-government programs, for example, and we see this in coming out in the United Nations e-government surveys, you have autocracies which provide these kind of e-government services to citizens to simulate or to create the impression that they are very close to their citizens, that they are extremely transparent, and the same is done with e-participation regimes. The autocratic regimes may use blogs or web pages which allow the citizens to interact with government services or with government officials, either at national level or at local level. And once again, this creates the impression that there is true participation and responsibility and accountability. And here we see Bahrain, Singapore, Kazakhstan. There we see examples of this. They have a lot of experience with that kind of use of the internet. And then finally, they can, and autocratic regimes do this as well, they can use the internet to disseminate propaganda. And this is something which is done increasingly. So these new methods, the new methods that we have witnessed in recent years, can be used in a very proactive way by autocratic regimes. And this is an indication of how they are making increasing use of the net to increase their own legitimacy. And that, of course, once again, has consequences for access to individuals through the legal measures that have been adopted, but also has consequences in terms of general social control in these regimes.
Thank you very much. Ahora tiene la palabra.
Now, Mr. Kenneth Page has the floor from Privacy International and in charge of Privacy International as well. Thank you.
Chairs and assembled committee members, thank you for the opportunity to participate in this very important hearing. It's good to see human rights and surveillance technology moving higher up the EU agenda. I work with Privacy International, a London-based but globally focused non-governmental organisation, on the increasing trade of surveillance systems from companies in technologically advanced countries such as the UK, Germany, France, Italy and the Netherlands to various repressive governments around the world. In 2014, we formed the Coalition Against Unlawful Surveillance Exports alongside Amnesty International, Digitale Gesellschaft, the International Federation for Human Rights, FIDH, Human Rights Watch, Reporters Without Borders and the Open Technology Institute at New America. The cause website is globalcause.net and members call on governments that export surveillance technologies to modernise export controls in light of increasing evidence that surveillance technologies are being used to violate human rights. The purchasers are often governments and law enforcement agencies of repressive regimes, which use surveillance systems to spy on their own population, leading in turn to arbitrary detention, beatings, torture and extrajudicial killings. They use a wide range of technologies to secretly monitor and track political opponents, journalists, human rights defenders, members of their own diaspora and many others. They include advanced intrusion software, specially designed to avoid antivirus software, IMSI catchers, which act as a false mobile phone base station, taps for undersea fibre optic cables, and so on. The technologies are diverse and customizable to each client and are accompanied by the provision of installation assistance, training and technical support. The continued technical support as part of some contracts means the working relationship continues long after any installation or transfer occurs. Yet there is a lack of transparency and accountability regarding what is being sold and who the end users are, raising serious human rights concerns. Over the last year, many members of the Cause Coalition have detailed the increasing use of surveillance technologies by various governments. In their Enemies of the Internet report, Reporters Without Borders cited many instances of technologies targeting journalists and bloggers in Vietnam, China and elsewhere. FIDH has succeeded in pushing for the opening of a judicial investigation into allegations of complicity in acts of torture by French surveillance companies in Syria. Human Rights Watch released a comprehensive report on surveillance in Ethiopia, and Privacy International published a report on the extensive use of surveillance in Central Asia, including the use of lawful interception technology, and has also filed criminal complaints in the UK on behalf of Bahraini activists and an Ethiopian political refugee who were targeted using European-made intrusion software. Evidence has emerged of the Bangladeshi elite police force, the Evidence has emerged of the Bangladeshi elite police force, the Rapid Action Battalion, attempting to purchase mobile phone monitoring technology and subsequent training from surveillance companies in Europe. The RAB has been called a death squad by Human Rights Watch due to its operating culture of extrajudicial killings and has been criticised recently for its human rights abuses here in the European Parliament. Allowing an agency complicit in arbitrary detentions and killings to identify individuals on a wide scale is deeply worrying. Last year, leaked documents showed the Egyptian Interior Ministry was trying to purchase surveillance technology capable of monitoring social media. Last August, internal documents from a Gamma International server showed their FinFisher product, along with the provision of technical support, being used in Pakistan and also by Bahraini services targeting activists in the UK, journalists and human rights lawyers. In 2011, a variety of reports showed the involvement of monitoring technology from German and Italian companies in Syria. Often the only opportunity for controlling the flow of surveillance technologies occur via international sanctions or embargoes. It must be recognised that these tools can be used for internal repression, and the EU should automatically include in embargoes technologies that could be used to spy on and repress citizens. In 2014, evidence showed intrusion software from Italian company Hacking Team was used to target journalists based in the United States working for an independent Ethiopian media service. In 2012, the same technology was used to target Moroccan citizen media group Mamfakinch, a group essential in promoting independent journalism. This type of intrusion software can copy files from an infected device, record Skype calls, emails, instant messages and passwords. It can also turn on the camera and microphone of the device without the user's knowledge. Hacking Team advertises its product for targeting hundreds of thousands of people and the one to use to monitor targets who are using encryption and are outside a government's borders. The company, like many others, says it only sells its equipment to government end users. Modernising export controls are urgently needed, and there is a role for the EU to play. The first step is ensuring that all relevant technology is actually subject to licensing restrictions. Today, surveillance technologies such as undersea fibre optic taps and mass voice recognition equipment still do not require licenses. Any EU export policy relating to surveillance technology should place human rights at its heart, and we welcome the Commission's recognition that security is intertwined with human rights. A human security approach to assessing licence applications is essential, meaning that the human rights impact of a potential transfer should be appropriately assessed. There must be greater emphasis on human rights and a thorough risk assessment of the end user and of the legal framework governing the use of particular technologies in the destination country before an export takes place. Applications for the export of surveillance technologies to end users with concerning human rights records should be reviewed with a presumption of denial. Only last week, the European Parliament called for a ban on exporting surveillance technology to Egypt, which could be used to spy and repress citizens. Last November, the European Foreign Affairs Council recognised that the technologies could be used in connection with human rights violations, particularly as regards technologies used for mass surveillance, monitoring and tracking. The difficulties in controlling transfers and sales of technologies in the Internet age are clear. However, one can no longer turn a blind eye to the consequences of uncontrolled proliferation. Ensuring that the trade in such technologies does not undermine human rights in third countries requires a comprehensive set of measures, including placing greater responsibility on industry for proper due diligence and transparency, licensing requirements, and using the soft power of the EU to promote good governance and human rights obligations. Export controls are not a silver bullet, but they are an essential component of a comprehensive strategy. Industry too needs clear and precise controls, as well as consistency in implementation. Protections for security research and open source software need to be explicit and upheld, as well as a relaxation of controls on cryptography, which is often used to help protect individuals from surveillance in repressive countries. The key challenge is finding an appropriate way through which to stop risky transfers, while also not catching the tools security researchers need, for example, to develop tools that help human rights defenders. The aim is to only control items that are specially designed and marketed for use in intelligence gathering and law enforcement by government agencies. This requires security researchers and civil society be involved in any policy formulations and definitions. Civil society can contribute significantly in this area, and the EU should take this into account when forming a review mechanism of EU export policy and a regular review of the dual-use list. There can be a significant contribution on human rights abuses, technical analysis, or risk assessment for inclusion or removal of equipment from a dual-use list. There needs to be capacity building between the licensing authorities to ensure accurate information sharing and a consistent understanding of the technologies and risks in question. Having an independent EU mechanism through which to control surveillance technology while not impacting security research is essential and could, for example, involve the use of a catch-all clause which takes into account end use and end user. The EU has been presented with an opportunity to examine its approach to exporting these technologies to repressive governments. The Arab Spring showed how such governments use European-made technology to violate privacy, stifle political participation and crush free expression. Licensing will further force exporting governments to openly justify their export policies. This month, the Swiss government was forced to reveal the destinations for 21 export licenses for mobile phone monitoring equipment, IMSI catchers. These destinations included Ethiopia, Chad, Turkmenistan and Yemen. In Switzerland, human rights issues weren't deemed sufficient enough by authorities to deny an export. This is a chance for the EU to ensure human rights does have that authority. Yes, this is an issue of trade and technological innovation, but it is also an issue of human rights and of European values. Thank you.
Thank you very much, Mr. Page. And now, Madam Sarah Kuhne, Senior Legal Researcher, you have the floor.
Thank you. Thank you for the opportunity to participate in today's hearing. My name is Sarah McCune, and I'm Senior Legal Advisor with the Citizen Lab at the Monk School of Global Affairs, University of Toronto. For over a decade, the Citizen Lab has researched and documented information controls that pose threats to human rights. We do this by using a mixed methods approach that combines technical forensics with legal and policy analysis. We've seen that the human rights risks presented by digital threats are exacerbated by the quandary in which society now finds itself. Nearly all parts of society are wired in some form, but only a privileged few are adequately secured. And rarely do those privileged include civil society actors. Such imbalance presents a golden opportunity for government actors to exert digital control, not only over their own populations, but also dissent originating from abroad. It also creates points of leverage for threat actors that may not be government-linked. We have only just begun to scrape the surface of this rapidly evolving situation. Through our research, the Citizen Lab has sought to provide empirical evidence regarding digital threats. We recently completed a 4-year study of targeted digital threats against civil society organizations and published a report, Communities at Risk, that details our findings. Today, I'd like to share with members of the European Parliament what we do know regarding the characteristics and impact of targeted digital threats, but also some thoughts on what we don't know, which unfortunately is quite a lot. And we should find out, as a matter of priority, these answers to these questions through collaboration, transparency, and accountability initiatives. I will then conclude with some final recommendations. Some thoughts on what we know. First, in the digital realm, civil society organizations face the same threats as the private sector and government, but are equipped with far fewer resources to secure themselves. We've seen that some of the same threat actors targeting civil society also have targeted companies and government entities. We've identified 10 distinct targeted malware campaigns in our study, 5 of which had connections to threat actors and previous campaigns known to target government and private industry. Second, counterintuitively, technical sophistication of malware used in these attacks is low, but the level of social engineering employed is high. This is the case especially when juxtaposed with the commercial lawful intrusion surveillance kits that we've examined in other research. The majority of computer exploits that we observed in our study were for known vulnerabilities that have been widely reported on and patched for long periods of time. We encountered only one zero-day exploit over the entire length of our study. This raises the important point that impact does not necessarily correlate with technical sophistication. Some of the most significant impacts are generated from the deployment of relatively unsophisticated malware. As once a compromise occurs, basic malware is no more or less dangerous than more advanced malware. Even unsophisticated exploits can permit installation of Trojans that will permit exfiltration of files and contacts and activate video and audio recording on devices. Accordingly, while addressing the use of advanced intrusion software and IP network surveillance systems is essential, the problem is not discreetly confined to such technologies, and export controls are but one element of the response. We must concern ourselves as well with the broader practices at play and make sure we address more generic and in-house capabilities that may never implicate official export channels. Third, digital attacks against civil society organizations are persistent, adapting to targets in order to maintain access over time and across platforms. Such persistence demonstrates a disturbing level of commitment by an attacker to a target, and it is highly probable that this targeting is based on political and strategic rationales. Fourth, targeted digital threats undermine civil society organizations' core communications and missions in a significant way, sometimes as a nuisance or resource drain, but more seriously as a major risk to individual safety. At one end of the spectrum of severity of impact, targeted digital threats can undermine organizational efficiency, as staff time required for mission objectives is instead allocated to assessing and remediating an attempted intrusion. There are significant financial burdens associated with intrusions as well. Apologies. Security assessments, remediation, secure communications infrastructure, and technically proficient staff are all expensive and typically priced for a commercial market rather than struggling nonprofits. More significantly, targeted digital threats generate psychosocial impacts. They have resulted in chilling effects on online expression and use of particular digital mediums. For example, digital tools such as Skype and WeChat are both popular with audiences and effective in communicating with individuals around the world, but are known to have been targeted for government compromise in the past. They're therefore frequently avoided by civil society actors.
Excuse me. I think you are too fast. Interpreters cannot follow you.
I'm sorry.
So you should be slower. Okay, thank you.
My apologies, I'm sorry. Beyond chilling effects, impacts can include emotional and psychological strain. For example, within our study, one individual described the discovery of an active compromise of a Skype account as a huge invasion. She noted that it was quite upsetting and sort of paralyzed them emotionally for a few days. In the most serious instances, targeted digital threats have the potential to compromise an organization's human rights mission and individual safety. For example, Citizen Lab recently documented a customized malware attack against a Syrian citizen media group critical of the Islamic State of Iraq and Syria, ISIS. The attack was designed to obtain data revealing the group members' physical location and may have been the work of ISIS-linked hackers. Other cases have been documented in which information obtained through the use of digital surveillance served as the basis.
Por favor, un momento. La intérprete de italiano es...
The Italian interpreters are signaling from the booth, asking the speakers to slow down.
Obtained through the use of digital surveillance has served as the basis for arrest, detention, and even torture. Finally, what we know of impact is that targeted digital threats extend the reach of the state or other threat actors beyond borders and into what were presumed to be safe havens. Digital espionage and cyber attacks provide an effective means for threat actors, including state-linked attackers, to compromise groups and individuals located beyond physical borders. Diaspora and exile communities are frequently involved in discussion and support of rights movements in their country of origin. Our research indicates that threat actors use targeted digital threats for extraterritorial compromise, to surveil and undermine overseas-based opposition, as though those individuals were still in the country from which they fled. For example, within our study, we saw Tibetans targeted as a community for intrusion and digital espionage, with organizations located in Dharamsala and North America subject to constant attack. We've also seen the targeting of overseas exile organizations in the context of Ethiopia and Bahrain. A few thoughts on what we don't know, around which more research inquiries and transparency initiatives should be structured. The relevant actors and products. At present, we have no way to ensure a high-level, comprehensive, and up-to-date visibility into this space. What mechanisms are possible to acquire such visibility? Companies' internal mechanisms for evaluation of human rights risks and grievances are also a topic about which little is known. How can we better ensure corporate social responsibility measures and regulatory compliance are themselves open to public scrutiny and dialogue? More information is necessary about distribution chains, resale and transshipment of sensitive technologies. Many dual-use technology companies rely on distributor networks and other mechanisms for product sales that render them one or more steps removed from the end user of the product. We need more information about those distribution models and participants in such networks in order to strengthen accountability and oversight. Finally, who is affected? We know for a fact that civil society is targeted, yet many of those affected have yet to be revealed, and more comprehensive action needs to be taken to uncover such intrusions. In terms of recommendations, while the outlook for human rights in cyberspace has grown increasingly ominous, we are at a stage right now where smart and effective pushback against practices that infringe human rights is still possible. We need more tracking and documentation of digital threat incidents. Concerted, collaborative efforts around gathering and analysis of data that respect the confidentiality and other concerns of those affected are essential. Trade-related measures such as export controls with a focus on end users and end uses are important to address digital threats. But at the same time, such measures must go hand in hand with political support and concrete sustained assistance to civil society actors affected by digital threats. Diplomacy should unequivocally stress that civil society should be off limits for digital espionage and attack, and confront the extraterritorial nature of digital targeting. States should also support a wide mandate for a special rapporteur on the right to privacy within the UN human rights system, which could serve as a linchpin in efforts to document and address digital threats. More action is necessary to rectify imbalances in public access to digital security. The gravity of this situation requires a rethink of the security standards applied in software and hardware used by the average person to democratize security solutions and prevent compromise in the first instance. We need to further explore options for privacy by design and end-to-end encryption, and business models that do not rely on advertising methods that might undermine privacy and generate security holes. With respect to civil society in particular, sustained, committed technical support is required to improve awareness, prevention, and response. In the private sector, human rights considerations must be normalized and understood as a part of doing business for all companies, large and small, as well as new market entrants. Introduction of transparency requirements in the surveillance industry is an important first step. Finally, security-related research and tools must be protected and encouraged. Cooperation with the technical community is critical to developing lasting solutions that protect society from digital surveillance and intrusion. Lawmakers should explore options for safe harbor legislation addressing security research that is in the public interest. Governments should also pursue policy measures to curb the growth of the market for tools that undermine encryption and digital security standards and avoid driving such demand themselves. Thank you.
Muchísimas gracias, señora McCune.
Thank you very much, Madam, and do apologise for interrupting you. Apologies also to the interpreters if they've had problems following maybe it's my fault because I confined our speakers to 8 minutes, and I know that everyone has a lot to say. Some people have more experience with interpretation and speaking slowly, and others have less. So I'd like to thank the interpreters for their efforts and their professionalism, and thank you, Madam, for your efforts and your excellent presentation. Now for the final comments, I'd like to give the floor to Mr. Vincent Michalski, Director of Human Rights Watch in Germany. Thank you very much and good morning. If it's all right, I'll be speaking German. I might switch into English here and there because our lingua franca is English, but I feel more comfortable in German. I was very impressed by the first panel on export controls. There were so many people here, it was standing room only. We see that now we're talking about human rights implications and there are less people in the room. I hope that's because they have other engagements elsewhere. I hope it's not a bad omen for our issue. During this panel, we've heard that there is great agreement about how important human rights are when dealing with export of surveillance technologies. That wasn't so much the case in the first panel, and that's why during my comments I'd like to concentrate on what was said during the first panel, but not solely on the first panel. What Mr. Christian Heuchert said was quite striking, and his interpretation of innovation and technology. That reminded me of dark moments in the 20th century. The invasion of technology was seen to prevail over everything else, and human rights didn't have a look in. What Mr. Nordeus said was also interesting. I have some understanding for what was said, but perhaps I can see that from another angle by giving a couple of examples about what Human Rights Watch has researched into over recent years. When the Arab Spring was just beginning and the Mubarak regime fell, a German TV team was in Cairo and found a letter from a German surveillance technology firm where that firm was offering to the Mubarak regime that they take over the surveillance of dissidents. It said, more or less in that letter, you have a problem with your rebels and we can make sure that that problem gets solved. Now, the Sisi regime has made a public issue of purchasing European surveillance technology because it's efficient. The Sisi government carried out the worst massacre after Tiananmen Square with mass executions, and because of police and military surveillance they were able to silence the opposition by putting them in jail. Despite that, they are shamelessly striving to get hold of European surveillance technologies. Another example, Syria. 2011, EU member states ensured that surveillance technology exports to the Assad regime were stopped. That was only in 2011. But secretly, those exports are probably still taking place. Human rights defenders are being sent to jail after having been checked up on with these surveillance technologies. Their families are threatened, many are forced into exile, many can't leave the country. In Ethiopia, Ethiopia is a country where European surveillance technologies are used in a very clever way, an extensive way. In March 2014, Human Rights Watch published a report where we demonstrate how the opposition, dissidents and journalists are being persecuted with the help of European surveillance technologies. They end up in jail, or they disappear, or they're tortured, or they are killed. And even with the assistance of this technology, they are surveyed in exile. For example, someone in Norway, a dissident in Norway talking about the opposition movement in Ethiopia in Norway is listened to in Norway, and his family in Ethiopia is put under pressure to bring pressure to bear on that dissident to force him to stop making use of his right to free expression. So without you even noticing, this technology can trigger the camera or the microphone in your telephone. You don't even notice anything. It's very clever technology, and this technology has fallen into the wrong hands. That's why Mr. Horschet's or Fukami's arguments are something I can't follow. Clearly we have to have innovation, we have to have scientific progress. It would be silly to oppose that, but not at the cost of human rights, as in these extreme cases that I've just described. So really, it's ridiculous that Mr. Horschet says he's a member of an organisation which has been fighting for citizens' rights since 1980. Whatever he says, please take it with a pinch of salt. What Mr. Nordeus said is something different. I have great understanding for the economic interest, the fact that we all have an interest in progress. That means jobs, competition. But there, once again, there are limits. And if you take seriously what I've just described, and I'm assuming you do, then you will self-regulate, and you will not object to exports being controlled. If there are any questions, then you can pick up the phone and call the Ministry of the Economy and ask, this technology that I want to export, is it okay? Or is there anything in it that needs to be regulated, that is under regulation? And then you can react to that. The important thing is that despite competitiveness being necessary so that these technologies outside the EU sidestep regulation, obviously there is that advantage. We don't want to play to that advantage, but the next step needs to be worldwide regulation at UN level. That would answer this point about competitiveness. Thank you.
Muchísimas gracias, señor Michalski.
Thank you very much, Mr. Michalski. I'll give the floor now to the members who have requested to take the floor, and then to the External Action Service. I imagine that Mr. Nieves Fernandez is here. Unfortunately, the European Commission, for a number of different reasons, has decided not to take the floor. But the External Action Service is here, and at this point I'd like to give the floor to Mr. Weidenholzer.
Frau Präsidentin.
Thank you very much, Chairman. Mr. Michalski, I think you're absolutely right about the fact, your observation that there are fewer people in this particular session, in this second session. it's not necessarily because people are not interested in this particular human rights aspect. Undoubtedly, this issue has to be seen in conjunction. But when one looks at the different colleagues that have spoken, one gets a feeling of kind of inability to act, if you liked, and simply one collapses with all of the information that's been presented. Perhaps 2 or 3 years ago, one could have discussed these particular issues with greater optimism, because the technical possibilities and the legitimacy of our proper use of this particular technology was seen with greater optimism. I've looked at this issue has been discussed on other occasions in Strasbourg. I've heard that from other colleagues as well, that stability, to have some sort of stable targets on these particular issues, is something which is absolutely imperative. So I think that the point of view that it's important to look at this in conjunction with international trade, and the word control, of course, comes to mind. I think indeed this is the way to go, to look at this particular issue in a framework of control, but also the industry and the phenomena together. I think that this is one of the most important things, is that we in Europe have to think about what we're going to do, because we can't just simply go along as if everything is fine. We've heard about the various problems that exist throughout the world. When we look at this through the prism of the events of the last couple of days with Charlie Hebdo, undoubtedly major discussions and major issues come to mind. That there are situations that we have to look at which go far beyond Europe, and very serious violations of democracy as well have to be taken into consideration on this point. Thank you very much, Madam Lopilar. Thank you very much, Chairman. I'd like to thank all of you for the very interesting presentations and statements. I have a question for Madam Knoyer. You described how autocratic regimes deploy these particular technologies, and I come to the conclusion that at the EU level, what we need is a very detailed list of what the situation is in each one of these countries that were discussed, and excluding the possibility of allowing certain technologies to go into the hands or to the use of certain regimes from the EU or from companies based in the EU. So I wanted to ask if you're also, what your view is on a list of that nature. It's unfortunately that DG Com Trade is no longer here, because I had a question which I'd like to pose, because we heard earlier on that it's difficult when one looks at the human rights issue, what types of technology ought to be forbidden or banned and which not. But also one has to look at where, when one looks at where these particular technologies are exported, it's not that difficult. So we have clear assessments of the level of democracy in different countries and the human rights records of different countries, and to those countries it would simply be very, very simple to ban export. Now, Madam Ead Knoyer mentioned furthermore, and others as well, that we have human rights defenders and organizations that have to be protected with further education and possibilities, and what sort of technologies can be deployed for that purpose in order to refine the situation. And also training that might be provided for organizations of this nature. And I simply wanted to ask, what sort of demand exists, and if there's an increase in demand for training in the use of these particular technologies to disseminate information as well. A question for Mr. Page, in English now.
We have reports how this has been misused and who has exported which equipment, from which country or from which company. Do you also have examples where companies have sold such technology to non-state actors? For example, I remember, I think it was in 2011 or 2012, I'm not exactly sure. I had a phone call with a company based in Bavaria, my home region, who was maintaining equipment in the Ministry for Intelligence in Syria. It was difficult to get this phone call already. But then I asked also, now, as you say, you are not interested in whom you sell this. Would you be able to sell it to the democratic opposition in Syria as well? And then his frank answer was, well, why not? So I was wondering if there is a market also to such organizations. Thank you.
Thank you very much. Mrs. Quistot-Crowell. It's very difficult for me to say your name. Excuse me.
Excuse me, I'm not responsible for my name. I received it from my father and from my husband. Yes, thank you very much. It was very well pronounced. Okay. Ja, und vielen Dank für Ihre...
And thank you very much. Thanks to all those that have come here today. What I do question, now if I've understood the title here, very, very much the issue of export controls have been brought up, and being against export controls, that when these are introduced, then we don't have these technologies available. The cutting edge of technology is no longer available, and we have to remember that there's world competition with other countries or other regions as well that produce these types of technologies. I think export controls are fine, but when one knows where things are going to be exported to and what can happen, who is going to use these technologies, if one has this particular knowledge, then one can be more influential. So I think one not focus on the fact that we have modern technologies that we cannot export. Exports and human rights. I'm not sure if I don't understand why the issue or what the issue of human rights is reduced in this particular view. Undoubtedly, it has to be part of the story. No question about that. Madam Schaake and I, we sit together as full members in the INTA committee for international trade, that is, and for that reason we find ourselves here together discussing within the human rights subcommittee these particular issues, because we want these two issues to be joined, the issue of human rights and international trade. This is a question for all speakers. Independent of export controls, what can the EU do? How can we be more effective, more influential as far as countries, autocratic regimes, dictatorships, and so on and so forth, on the issue of human rights? How can we influence them as far as, if you like, use of new technologies which conforms with the principles and the fundamentals of human rights? There are numerous different issues that have been posed, and I simply wanted to ask what your critical point of view is. with regard to the involvement of human rights in these issues, if you have any fundamentals or principles you'd like to present. Chair, thank you very much. Mr. Bashir.
Madam Chair, I too am not responsible for my name. It was given to me by my father. I'm proud of my name. My name is Bashir. It is one of the names given to the Prophet Muhammad. It means bearer of good news. But having a name like this does have its problems. Not so long ago, going back to my home country in England, Manchester, I tried to use digital technology with my passport and it wouldn't accept it. So I had to go through the normal channels, and I inquired why I was not allowed through the digital way. And they said, Bashir, there are hundreds and thousands of Bashirs, and therefore the machine throws them out and throws them to us. I'm obviously against mass surveillance and mass profiling. Another incident, again in Manchester, I was stopped and questioned over several hours. I realise that we've got a problem in Europe with terrorism, and therefore I'm not against being questioned. I want security. But again, I'm against mass stopping of people by profile. I think if you have targeted information, that is the best way. I recently visited Peshawar in Pakistan, as you know, the scene of a horrendous attack where 145 people were killed cold-bloodedly, mostly children, by the Tariq-e-Taliban. Now, due to surveillance, the Pakistani security forces were able to determine that they were being guided by people from Afghanistan across the border. They were able to pursue these people and take action. Most of them were suicide bombers that killed themselves in the actual school. So that's surveillance, in my view, which is positive. But then again, I visited Karachi, where I learned from a political group, large numbers of their members are missing. They were taken by the security forces, and 2 years later there's no information about them. Their mothers and their wives and daughters were crying in tears because they have no information, and the authorities have not informed them if they're alive or dead. Many people go missing and are killed. So there's something that is despicable and wrong. Now, when you export equipment abroad, I think this question is to Mr. Page in particular. Obviously, one instance that I mentioned is positive, where the security forces were able to follow these terrorists and take action. And the other is very negative, where political opponents are going missing and by the security forces. How do you sell equipment to regimes or countries and then keep control of its use? That is very important. Thank you very much.
Thank you very much. Voy a dar la palabra ahora a la señora Fernández.
Madam Fernández del Cotero from the External Action Service will now take the floor. And then, of course, our panel members will be able to respond to the various points that have been made. Madam Fernández Cotero, please.
Good morning. First of all, we would like to thank the European Parliament for hosting such an important event as the impact of digital surveillance on intrusion systems on human rights in third countries is nowadays a topic of priority. We would like to highlight that the freedom of expression online and offline has been part of the EU Action Plan on human rights during the last 3 years. As part of this plan, in the 12th of May 2014, the human rights guidelines on freedom of expression online and offline were adopted by the Ministry of Foreign Affairs. And I would just like to go very quickly through some key principles that are stated on those guidelines and I think are extremely relevant for all the work the EU is doing right now. The first one is that the right to freedom of expression, the right to privacy, and the protection of personal data may suffer violation as a result of unlawful or arbitrary surveillance, interception of communication, or collection of personal data, in particular when carried out on a mass scale. And therefore, the EU says that states must ensure that any measures taken to protect certain information gathered and processed in the interest of national or public security are in accordance with their obligation under international human rights law. This is agreed language at the Foreign Council, and therefore the EU has committed to promote measures for the protection of the right of privacy and data protection, including by calling on and supporting third countries to bring the relevant national legislation regarding transparency and proportionality of government access to personal data in conformity with international human rights law. We have also committed to promote and facilitate the exchange of good practice to ensure that the legislation and procedures that the states regarding the surveillance of communications and the interception and collection of personal data are based on the rule of law, subject to independent and effective domestic oversight mechanisms, and upholding obligations under international human rights law. Just as an example, I would like to mention some recent activities that the EU has been carried out since the adoption of the guidelines. The first one is that during its 18 bilateral human rights dialogues with third countries since the adoption of the guidelines, we have been raising the issue of the adoption of the new guidelines and encouraging third countries to take active steps to prevent undue interference. Additionally, we have also been holding EU cyber dialogues with strategic countries where we have also advocated for the protection of human rights online. The EU has been actively engaged on strengthening international efforts on the promotion of freedom of expression online, and we have been closely following the work of the Freedom Online Coalition and the United Nations General Assembly resolution on the right of privacy in the digital age. The EU is also extremely engaged in the debates of the Internet Governance Forum, and we are looking forward for the 10th year review of the World Summit on Information Society. We are also looking forward to the Hague Cyber Conference Forum to be held in April, where we hope to still encourage the promotion of a human rights perspective in the digital sphere. The EAS and the Commission have also actively participated in the Net Mundial multi-stakeholder meeting in Sao Paulo, and we have endorsed the meeting statement in which the Internet governance principle clearly affirmed that human rights, in particular freedom of expression, freedom of association, and the right of privacy, must underpin the government of the Internet and must be upheld online. We are now just working on cyber diplomacy conclusions. We are on the latest stage in the Council Working Group, and in its current form, they take a holistic approach of cyber issues, including with regards of the protection of human rights, recognizing that these values, the EU and Member States should actively contribute to the enforcement of international human rights obligations in cyberspace. We also welcome the Council conclusions on Internet governance that were adopted on November 2014 and that should be mainstream on all the cyber-related areas for the EU action. We have also created an internal informal inter-service group on freedom of expression, which is actively working on all the issues related to surveillance and access protection of the personal data, and which we hope will continue to carry out their work during 2015. There have been several events where we have tried to stress the importance of this issue. The first one took place on the 22nd of September in the margins of the Human Dimension Implementation meeting of the OSCE. And one of the main issues raised by civil society as one of the most important things the EU should be taking care of is the unlawful interception and the effects it could have on human rights defenders. The EU is also providing training to its member states and diplomats from member states on what is the involvement of human rights in surveillance and the importance of the right of privacy. In the EU NGO Forum held in December 2014, we had a specific panel addressing the issue of access to information and mass surveillance and privacy rights. And we will hope to have in the future a full dedicated panel in the EU League of Arab States workshop on freedom of expression to access to information and the need of protection of the right of privacy. Just to conclude, let me tell you that the EES is now currently working on the new action plan on human rights, where all the reflections taken by these several events, and including this hearing, will be reflected to take action in the future on the protections of the right of privacy.
Muchísimas gracias. Y ahora por...
Thank you very much. And now I'll give the floor to our guests for approximately 2 minutes each. Let's begin with Mr. Larue. Thank you.
Gracias.
Thank you.
Comments. The first question was asked, what is the link of, a specific link of human rights and technologies and eventually of export of technologies? Not only in regard to states. I think that, number one, is all states have an obligation to promote economic development, yes, and to gain economic growth, but at the same time, and I believe more importantly, that activity has to be seen within the democratic framework of full protection of human rights and basic liberties of all people under its jurisdiction. But within the universality of human rights, there's also a principle that all states should look at the protection of human rights around the world, which is why we have multilateral bodies like the UN talking about human rights around the world. So there is a responsibility not only of our own citizens in every country, but there is a responsibility of all citizens of all countries. And I think this is very important when we talk about export licenses as well. Secondly, there's a corporate responsibility element, and here the UN, I didn't go too much into it, there are the recommendations of John Ruggie, which was the special rapporteur on corporate responsibility and human rights, which I think is crucial. Although the final responsibility is of the state, all of us in society, as part of the overall actors in society, in every nation, have a responsibility, and the corporate sector has a specific responsibility as well. And I think it is important to demonstrate this. So it's not only the states that have to monitor exports, but also the corporations that sell this technology. They have to have a very clear standard of who they're selling to, what is being used, and the follow-up of what they did with those technologies. And finally, let me finish. No one made the comment of what it does to us individually. And I think this is a very important reflection. We cannot allow violations of human rights around the world without having an effect on the entire world and ourselves. And we cannot be part of a nation that builds and establishes technology with good purposes initially, but eventually misused to violate other people's rights. Because sooner or later, that is going to be turned around and affect our own human rights and our own democratic standard. This is why I insist that the question of security is not in contradiction to human rights. That is a procedural aspect of how to establish security and how to establish legal democratic surveillance within human rights boundaries, but it is not in contradiction to human rights, because it is only a strong democracy that can have strong security, and that means the respect of everyone's rights. Otherwise, we all lose.
Merci, thank you very much. Yes, Mrs. Neuer.
Vielen Dank für die...
Thank you very much for the questions. I'd like to respond to both questions from Madam Christoforou and the other as well, where the EU has a kind of leverage power, if you like, would have leverage as far as dealing with use of new technologies which conform with the principles of human rights. Now, we've focused on export controls for surveillance technology. That doesn't mean that it isn't important. Of course, it's a very central and key issue, no doubt about that, but also it's very important for the European Parliament, particularly in this constellation, this combination, trade and human rights, that you deal with this particular matter. And I think one ought not focus only on export controls or feel that only with export controls one can solve the problem. Of course, one can make registers and lists. It's very useful, and it's also important to have some sort of differentiation there. But where I see the lever, the real tool, if you like, and the mission. Now, the EU is not only an exporter of goods and technologies, the EU is also an exporter of democratic standards, of norms, of human rights. And as such, I would say that there is a lever there indeed, an implement to be used. So the lever wouldn't be so strong perhaps in countries like China or Iran. It would be unrealistic to look at it otherwise, but there where the EU does have a strong lever power in its own household, if you like, or in the neighborhood, there I do think that the EU can, with its possibilities, not only with export controls or with those alone, but can couple this or link this up with other types of relations, or perhaps within the framework of neighborhood policy, it might work. And here, I also feel that it's not only the technological side that has to be looked at, but also the question has to be posed as to how we can deal with digital technology within the framework of civil society, but also within the framework of intermediary institutions or agencies, parties, groups, and so on and so forth. How can this responsible use be promoted, and how can it be supported? And here I'd like to point out that when one takes a look, net penetration in countries, and that linked to the degree of internet freedom. When one looks at these two components, one finds a group of countries in which there is a relatively high level of growth. In other words, countries where if technology is further developed within the framework of social economic development, that there is a decision to be made whether they'll go towards the direction of high-tech censorship or towards development of democracy. And when one focuses on these particular countries, when one looks at, for example, the MENA countries, European neighborhood policy as well, then one, I think, will have defined a very, very clear-cut group of countries with which one can work. Thank you.
Muchas gracias. Señor Page.
Thank you very much. Mr. Page, please.
I guess I'll address Madam Lochbiller's question first about the sale to non-state actors. There's really only one thing that would stop that, and that is if it's up to the company themselves. If they feel that they don't have to sell to a government agency, that will be their decision. Some of the technical aspects of some technologies will mean they will need access to the communications infrastructure or undersea cables. Only those actors that will have access to that will be the law enforcement agencies or government departments. But for things like intrusion software, if there's a billionaire oligarch that wishes to use such intrusion software or a fake mobile phone base station to capture the calls of a surrounding area, if that oligarch wants to use it for corporate espionage, there is technically nothing stopping him from purchasing it. So there is an issue of it being used by wealthy individuals that wish to use it for those reasons. We've also seen comments from some of the companies themselves. I mentioned Hacking Team, an Italian company, earlier. They said, we do not sell to repressive regimes, and yet we see their technology turning up in Kazakhstan and in Ethiopia. So simple statements from the companies themselves hold no weight in this. Dealing with what Mr. Bashir said, yes, there are legitimate uses for it in systems where there is legal and democratic oversight. Can you sell a technology and then keep control over it? No, not really. You would see it with UK and German technology that has been sold to, for example, Bahrain. Those security services then use it to target residents in the UK. And for me, that would raise national security issues. I'm sure that Bahraini services didn't promise to only use it in the country. The nature of telecommunications and the internet shows that it's transnational, it crosses borders. And there's no reason that they would stop at their own borders if they really wanted to track someone down. And I would say to Ms. Roval, exporting technology that facilitates, beyond export controls, exporting technology that facilitates repression, for example, to Turkmenistan, which is ranked 197 out of 198 countries in the world for press freedom, you're really only encouraging that country to continue its actions. And it really pulls apart the EU's statements from its actual actions. The end user and the human rights situation in that country, as well as the legal system in that country, needs to be examined before an export takes place. Thank you.
Thank you very much. Yes, please.
Yes, on the question of what demand exists for training and use of technologies that can provide more digital security, I think there is quite a bit of demand among civil society actors. There's more and more recognition of the fact that this is a serious problem, and if civil society groups aren't yet aware of a particular intrusion, it's probable they will become so in the near future. The important thing to consider is that support for training and security efforts needs to be long-term. It can't be one-off or ad hoc, because when you're talking about digital security, it's a topic that's very complex and a lot of times requires significant technical expertise. So this is something that needs to be conducted with a long-term view and perhaps embedded support within civil society groups and among activists to build a culture of digital security awareness and build onto communication platforms as much as possible built-in measures for digital security. On the question of selling equipment to countries, how do we keep control of such equipment after its use? To follow on what Kenneth said, I think one important first step is to engage in dialogue with companies about both what's possible and also what's required of them. As Kenneth mentioned, a lot of times there are ongoing service contracts with end users of this technology. What's possible in terms of contractual provisions that companies enter into with their clients. Also, what's possible with respect to transparency and accountability in distributor chains and requirements for regular reporting by companies. I think those are initiatives that could provide some more insight in this arena. Thank you.
Thank you very much, Mrs. McCune. Y ahora el señor Michalski también por un...
And now, Mr. Michalski for a couple of minutes.
Okay, very briefly. In response to the question of whether there is an alternative to export controls.
Ruggie guidelines sind halt nur guidelines.
These guidelines are unfortunately only guidelines. They are not binding. They're not binding directive, at least not yet. Export control may not be the most elegant solution, but at the moment it's the most effective one that we have. And as a human rights organization, we need to be pragmatic, and we need to see how we can defend people who are standing up for their rights and do that as quickly as possible. And this is the only means of prevention we have at the moment. Am I as critical of myself as of Mr. Sekumi? Yes, sometimes. But I think on this point, well, of course you always have to be very self-critical in everything that you do, because we are dealing with lots of different actors from lots of different backgrounds, and we have to weigh up all of the different arguments. And to come back to what was said at the very beginning, unfortunately, export controls are probably the most effective means we have available to us at the moment. Mr. Bashir then brought up an extremely sensitive issue of, on the one hand, the legitimate surveillance of tourists or of criminals, and on the other hand, the misuse of that surveillance. In countries where this has not been clarified, then you probably do need to limit, control, or perhaps ban exports. The question of whether the Pakistani Secret Service has monitored the Taliban using surveillance technology, or whether it has just used traditional spying methods of infiltration, etc., I think it's probably due to the fact that most of the Taliban activities are offline.
Sí, voy a dar un minuto la palabra, bueno, un minuto no, medio.
I'll give a minute and a half the floor to Mr. Leroux. A final 3-second comment. I forgot to mention that the principles, the guidelines, which have been established, that's a major step forward. And that's why it's very important for all the policies of the European Union, including that which involves the regulation of exports, that they go hand in hand with these particular guidelines, or that they fall within the framework of these guidelines. That is an important initiative. Yes, Madam Röke.
Very much, Chair, and thank you to all the excellent presentations and for all of you for sticking out such a long hearing. We've heard a lot of concrete proposals and thorough analysis of what is going on. And I think that it's clear that security or trade interests and human rights do not have to be and should not be zero-sum. They can and must go hand in hand. This is a multi-billion-euro market that is intransparent, and the vendors are unaccountable, yet the risks for our own security and for the human rights of people all over the world are significant enough to not accept the status quo of a legal vacuum, a legislative vacuum that we're trying to fill. And it's, of course, not the intention to hamper research. It is not the intention to repeat the crypto wars. We've learned from that. And finding a vulnerability in a software system with the goal of increasing security will not and should never be met with the same response as selling that vulnerability to the Islamic State or Bashar al-Assad and his law enforcement services. That is what we're trying to avoid. And I would like to extend an open invitation to Fukami and other experts in the Chaos Computer Club to work with us to create smart European legislation where all concerns are adequately dealt with, but where cutting-edge technological solutions are also taken on board. We need smart and targeted policies. We should be more precise than what has been agreed in the Wassenaar arrangement, and I think that we should advance the frontier, raise the bar and seek multilateral agreements in this context. So not end in the EU, not think that this is the only solution that we need, but really make a start in getting the smartest possible legislation. And those who suggest that self-regulation could be a solution should really think twice, because there are a few companies in this market that have a public reputation. But I can guarantee you that the most significant actors operate in the dark. They don't have a reputation to lose. They are not interested or held accountable by self-regulation. So it is not a solution for this entire market. I think it is very important to keep in mind that this is a discussion that has to reflect in domestic EU-wide policies as well. We cannot touch upon those today. But the notion of Mr. Leroux that mass surveillance is always contradicting universal human rights is one that is significant and one that we have to act upon. We also have standards to deal with, standards that we set here in the EU, and this is also part of the answer to the question to my colleague Godelieve, because we set standards, for example, as to what telecom systems should look like. The EU requires that networks of our mobile phones have lawful intercept capability, so a backdoor that the police can open if they want to look for suspects in a criminal case or terrorism case for that matter, only after a court order. And so who decides what is lawful is really important. If we look at these standards in the context of the rule of law that we cherish here in the EU, that we seek to improve, it's a very different context than exporting those systems all over the world where we've established that the rule of law does not exist, thereby having EU standards creating a permanent backdoor to whoever has the authority to open it to spy on citizens, journalists, activists, and anyone who might be a threat to them, or our companies operating in that country, etc., etc. So I believe that we have to look at what we sell, as Ms. Lochbihler said, but also where we sell it to and what is going on there. And I think we have so many cases where there has been open and official EU condemnation of political developments in third countries, but that we do not ask ourselves with which tools are these people repressed, and that we do not ask ourselves, could these tools be made in Europe? And we have to find out to the bottom what this market looks like and prevent that made in Europe technologies are used for repression. And I was actually quite curious of what the Memorandum of Understanding between the European Union and the Arab League to fight terrorism is going to entail. Because we should avoid at any cost that on the one hand we have good guidelines that the European External Action Service now works with on the freedom of expression online and offline. And on the other hand, we see tenders being written by the Egyptian government seeking European technologies that could well be used to repress dissent, because we see that this repression is rampant. So I believe that there's a lot of room and an urgent need for an ambitious agenda for the next steps, that the EU should lead, and that indeed this may sometimes be difficult for market interests, but that we have something of greater value than economic value, and that is our fundamental values, our responsibility to lead with regard to those human rights in the world, and that it has to be an integral approach. And therefore I think this hearing was very important to look at how trade and human rights influence each other in this very specific space of rapidly developing technologies. So thank you all.
Muchas gracias, señora Schaake. Espero que...
Thank you very much, Madam Schaake. I hope that your report, which will be an extensive one, will facilitate this entire process. And finally, the DG Connect was unable to be here today because they had another event to attend to, DG Justice as well. But Pablo Garzotti from DG Training, I would like to thank him very much for his presence today, and I'm going to give him the floor as well. He'll speak to us on behalf of the European Commission. But Mr. Garzotti, with so many people working in the Commission, how is it possible that somebody from the sphere of human rights wasn't able to be here? You were kind enough to stay throughout the entire session, so you'll have to respond for them. Thank you.
Thank you, Chairman. And we are here, we stay here because we care about this. We are in the process of having a reform. I say our Commissioner, the first oral question she replied in front of your Parliament, was on this issue, and we care about this. As a matter of fact, in our communication, we put human rights as a potential condition for denying export. It's one of the proposals the Commission puts forward. I just steal you 15 seconds to reply to the question of Madam Lochbihler. Of course, export controls is one instrument that we can use for this. That if we know that there's one state that clearly has not the standard to provide this, the kind of use that is needed for this technology, we have other instruments like sanctions, 215 of the treaty, and we think we should look as well at the whole broad spectrum of instruments that the EU has in place. But as far as DG Trade, the Commission in its trade, in external policy, trade policy is concerned, we will continue to be keen and to be here and to listen to you on this debate. Thank you.
Muchísimas gracias.
Thank you very much. Our next individual, our next guest is here for the next part of our session. The Special Envoy on North Korea from the United States. But I'd like to thank all of you for being here today and for participating in this ever so interesting hearing. Thank you.